but I don't want to spoil the fun, but we do have some stories to tell and questions to ask this audience. So without further ado, I would like to invite the global head of arbitration Kennedys, Thomas Kendra, who is based in Paris office, to have a few words.
Thank you, Oleg, and well done for the organization of this event, everybody involved. So yeah, my name is Thomas Kendra. I do international arbitration. I'm based in the Paris office, but I am English. I'm not putting on this silly accent. It's actually my own. But I've been in Paris for 20 years, and so I work both in Paris and in London. I'm an English lawyer and a French lawyer. Welcome to Kennedys. I am a relatively recent arrival myself, came in last November. But for those who don't know Kennedys, it's been around since 1899. I had to look that up. Something I did know is that we have 46 offices in 20 different countries around the world. We have 31 associated offices on top of that. So it's a big law firm. What you may or may not know is that it's really a market leader in insurance historically. It's been a firm that's very linked to the insurance markets, and we are still the #1 insurance law firm. But over the past few years, it's been expanding into different areas, consolidating different sectors, different markets, different jurisdictions. My arrival in international arbitration is one of that, a factor of that. Oleg as well, a partner here in international arbitration, Eridania from the New York office who's come over. So we really have a very strong international arbitration group that builds on the dispute resolution strength of Kennedys historically. Now, today we're going to talk about the enforcement of arbitral awards. As I say, I do international arbitration, so I've been doing international arbitration for 20 years. And I would just say the majority of international arbitration awards are enforced voluntarily. So in my experience, it's been actually few and far between the cases where we've had to start proceedings, go through proceedings, and then enforce awards against parties. Now, it's difficult to get statistics about how many cases, what proportion of cases are enforced voluntarily, because it's confidential, and also because tribunals, once they've issued their awards, they have nothing to do with enforcement. That's a particular aspect of arbitration. It's not like the courts, where the court makes a decision and then the court is also involved in the enforcement. Arbitral tribunals, once they've rendered their award, that's it. It's out off into the award is out there, and it's not up to them what then happens. So we don't know exactly how many, but the different surveys suggest different figures, like 70, 75% are enforced voluntarily. And that sounds about right to me, in my experience. In fact, possibly higher than that, but that also might be when you're working in a large law firm, it tends to be parties, large companies, etc., which are ready to enforce the award. Otherwise, they wouldn't have gone to arbitration in the first place. Why do parties enforce arbitral awards voluntarily? Why would you pay voluntarily? Why not wait until they come and then take your television away or whatever it is? Well, when you choose to go to arbitration, usually you've got an ongoing business relationship. So that's one reason. You know that the next time it might be you that wins the arbitration, so you will want the other party to enforce the award voluntarily. It's a clause, it's a choice to go to arbitration. It's not like being dragged before the courts. You've chosen to do it. So normally there's some kind of continuing business relationship. There are reputational issues. Now, arbitration is confidential. Basic system of arbitration is confidential, but there are reputational issues. If you go before the courts, it will become public. So again, it will get out there that you don't enforce awards voluntarily, and that might affect your business relationship. It can also be negative publicity. So this again can happen because of court decisions that make it public. But there are even arbitration associations which make sure there is that negative publicity. The GAFTA, the Grain and Feed Trade Association, keeps a register of its members that refuse to enforce awards, and it actually posts their names on a notice board, now a virtual notice board, saying this party is a member of our association and they refused to enforce an award. So it can affect your business relationships going forward. So I just wanted to focus on that fact of voluntary enforcement, just so we don't focus too much on the negative, but we focus on the positive. You know, it is in international arbitration, the vast majority of time, including state cases. I do a lot of investor state arbitration. I've worked for more than 10 states. And even in those cases, the states will tend to enforce voluntarily. But in general, that's the situation. Now here, we're talking about the opposite. We're talking about when they don't. And of course, you need a system, you need systems in place. That's when you need to turn to the local courts to get hold of assets, to enforce your award. And that is therefore exceptionally for arbitration, because arbitration is in an international legal order. But once you need to enforce, then you need to go to a local court. And so that's why we're here, and we're going to be discussing those. But I wanted to focus on the positive, and just bear in mind that if you're choosing arbitration, most of the time, you're going to get voluntary enforcement. So thank you. Again, thanks for the welcome, and thank you for coming here. Welcome to Kennedy's. And I hope we have an interesting discussion today.
As many of you know, in Ukraine, we do have quite an interest in arbitration practice in general. Legislation is catching up, and I see a few familiar faces here who were part of the arbitral reform, which took place not so long ago. And the driving force for the changing for the future is Ukraine National Bar Association. And we have a privilege to have Valentin Gvozdy from Kiev, I believe, online. So I would like to welcome Valentin to say a few words and intro words about the Ukrainian reality.
Thank you. Dear ladies and gentlemen, dear colleagues, on behalf of Ukrainian National Bar Association, I'm honored to welcome you to today's discussion. It is a privilege to join such distinguished experts to reflect one of the most important topics for global commerce and justice. The enforcement and recognition of arbitral awards across jurisdictions is very important. For Ukraine, this subject is not theoretical, it's very practical, it's urgent, and directly linked to the rule of law and economic recovery. As our country resists unprecedented challenges, the confidence of international partners, businesses, and investors depends on the credibility of our legal system and on the guarantees that their rights and investments will be protected. This is very important. The Ukrainian National Bar Association has a clear mission to ensure that Ukrainians' legal profession is strong, independent, and aligned with the best international practices. Let me stress that we recognize that our advocates are not only national actors, but they also guardians of transnational justice, and our rules of professional conduct and institutional framework are harmonized with those of the CCB and other leading organizations, not only in Europe, but around the world. We also focus on protecting the rights of investors and businesses in Ukraine. The credibility of state as an investment destination depends on its ability to guarantee enforcement of contracts and arbitral awards. No discussion on enforcement and recognition of arbitral awards in Ukraine today would be complete without addressing the profound consequences of Russia's ongoing aggression. The war has forced Ukraine to take extraordinary measures to safeguard national security and economic stability, and the measures have direct implications for international arbitration. One such measure is the nationalization of assets belonging to Russian state-owned companies and sanctioned individuals. By decision of Ukrainian courts and pursuant to special legislation, assets connected to aggressor state and tithes have been seized or transferred to the state. While these steps are essential for national defense and reparations, they raise complex questions when arbitral awards concern such property. Enforcement procedures must now balance private rights with overriding considerations of sovereignty and national security. Equally important are sanctions. Ukrainian courts consider sanctions not only as political instruments, but also in the context of public order in the sense of New York Convention. This means that awards in favor of sanctioned Russian companies or individuals may be refused recognition or enforcement because they contradict Ukrainians' fundamental principles of justice and security. Such cases demonstrate how sanctions regime have become integrated with arbitration law, setting new precedents that other jurisdictions may follow. Finally, international arbitration itself has been profoundly shaped by the war. Ukrainian investors and state are parties of numerous pending arbitrations, specifically against the Russian Federation, including claims under bilateral investment treaties and under the Energy Charter Treaty. At the same time, Ukrainian courts are tasked with enforcing awards rendered abroad while navigating wartime restrictions and damaged infrastructure. They are also complex legal questions. There are a lot of them. How to treat assets connected to sanctions entities, how to balance martial law restrictions with the due process right, and how to ensure that emergency measures do not undermine investors' confidence. Ladies and gentlemen, the world today is interconnected. No legal system can stand alone. Investors, companies, and citizens require assurance that justice will not stop at national borders. This is why our work, your work, is so critical. The Ukrainian National Bar Association stands ready to cooperate with all of you in building stronger cross-border recognition and enforcement mechanism in protecting investors and in reinforcing the principles of justice and unite us across jurisdictions. Thank you for your attention, and I look forward to our discussion.
Thank you very much. And I have welcoming remarks from Denis Demko from Ukrainian Embassy. Denis is looking at the perspective of recovery of Ukraine, and in particular for recovering potential assets which are now under the Russian umbrella. And I welcome Denis to the floor. Thank you.
Hello, everyone. My name is Denis Demko. I'm Economic Secretary in Ukrainian Embassy in London. And I think it's the first time in my career when I see so many lawyers and lawyer sector representatives in one room. Because I was always dealing with economy, and in Ukrainian Embassy, I'm responsible mainly for defense tech cooperation and sanctions issues. And quite weird combination. It was not my decision, it was the decision of our ambassador. He told me that, Denis, you managing defense tech cooperation, and let's add your sanctions issues as well. Look, it's very timely that you are sitting here and to have this particular expert discussion, and I'm really happy that these kind of topic would be discussed on these expert level, because first of all, 100-year partnership. It's a great opportunity for Ukraine and United Kingdom to strengthen our cooperation in different spheres of economy, in law and political ties, and so on and so forth. But without your expertise, it's just impossible, because you know better than I, our systems, they're a bit different. We have to humanize it. We have to develop our cooperation. And I believe that 100-year partnership, it's a huge opportunity for Ukraine to develop our future, our European integration. Defense. I work closely with the different sides of UK and Ukrainian defense companies, with a lot of them from UK side, the primes companies like MBDA, BAE. They try to make their steps to make some business in Ukraine with Ukrainian partners. And I see the lack of understanding from their side of how to operate in Ukraine, what kind of guarantees they have from the loyal sides, what kind of mechanism they can use if they have some problems in a legal environment. And of course, your expertise could be crucial in this area. The same situation in investment world. We try to develop our cooperation with the venture capital funds, with the private equity, with the family offices, with the London Stock Exchange. And one of the obstacles of investing into Ukraine, it's to understanding what is the legal guarantees they have to move forward, to step into investment into Ukraine. The same thing with the reconstruction, the same thing with the energy sector. And we face that your work is the most valuable nowadays and most important nowadays, because after all negotiations, after all the practical agreements, you step into the business and you try to make all of these, sorry for that, but paper routine, paper precise work. I know how difficult it is because I've been involved in the several project arrangement agreements preparation between United Kingdom and Ukrainian government. It's so difficult and precise work, and I really appreciate your input. And once again, we are an extremely timely gathering together here. It's very good that we have not just general discussion about how important to invest into Ukraine, how important develop our relations, but precisely discuss all the practical issues, all the practical steps, and to understand how we can move together, how we can develop our relation, and how we can make things happen. Thank you for that. Thank you for being involved. Thank you for being here, and thank you for having me here.
So I think it's time to turn to the substantial part of this panel. As we heard, arbitration offers a lot of solutions to the business world, especially in a particular situations when we have in Ukraine, for instance, where you have a defense tech as a sector which is booming. And in defense, the confidentiality is paramount. This is very important, and over the course of my career, I got a few cases with defense tech and just generally in defense, and confidentiality is always there at the first factor of consideration. So when we're talking about the forum to resolve disputes in a particular situations, arbitrations offer a lot. And in particular for Ukraine, as I said now, is quite important. But if we take in generally, although the arbitration being a universal tool, for dispute resolution. We all sit here in different jurisdictions and we have different nuances to how the arbitration practically work. So we have less sophisticated jurisdictions or less friendly. We have more sophisticated and more friendly. So all of those nuances obviously shape the perception of the business when you're dealing with a particular country. And since we have the Ukrainian aspects, and we do have quite a significant request from Ukrainian market to understand the nuances of different jurisdictions and how things are working, this panel, I think, is quite relevant and hopefully will be useful for the market players. So we have quite an interesting panel today from 4 different jurisdictions. And I start my introduction with Alexander Skart, who is the legal director and my colleague here in London. Alexander is a barrister as well, who is over 15 up to 20 years of experience in the profession. He's he used to work in various jurisdictions and know the region very well. And spend some time in the region of Eastern Europe as well. So Alexander will be talking about the nuances, the general approach of enforcement of the awards in the UK. Alex, floor to you.
Thanks very much, Oleg. Thank you for the introduction. So I'm going to be giving a bit of an introduction to the UK position but also I think hopefully setting up the position for my co-speakers who will be talking about America, Ukraine, and France. And there's sort of 4 topics I'm going to touch on. The first is enforcement generally under the New York Convention. The second is enforcement under the Exit Convention. The third is interim remedies in support of enforcement. And then finally, state immunity. And that sounds like a lot, and it is. So I'm going to try and be as brief as possible to give everybody else a chance to speak. Taking a step back, I'm sure most of you here know what the New York Convention is all about, but just in very brief summary, it's an international convention for the recognition and enforcement of foreign arbitral awards. It's a very old piece of treaty now, has 170 parties or thereabouts, and it's basically one of the sort of premier international treaties that have ever been entered into in terms of its success. Elements to it are that any contracting state is obliged to recognize arbitration agreements. And secondly, all contracting states, their courts are obliged to recognize and enforce foreign arbitral awards. And there are very limited grounds for objecting to enforcement. Very quickly, they are there's some incapacity relating to the parties. The arbitration agreement could not be valid under its law. There was some problems with procedure, or the respondent party was not notified of the procedure. There's an outstanding challenge relating to the award. And then finally, there's two reasons for objection which the court may invoke of its own motion. First of which is that the dispute was not arbitrable under the law of the place of enforcement. And the second one is the famous public policy objection to enforcement. So in England, basically England likes to think of itself as being a very pro-arbitration country. All those New York Convention grounds have been enforced more or less verbatim in the governing act in England, which is the Arbitration Act 1996. And so Section 103 of the Arbitration Act basically sets out these limited grounds for enforcement. However, the presumption in England is that awards will be enforced, but the grounds for objecting to enforcement are very limited. Basically, the court can only refuse enforcement on one of those grounds. Even if one of those grounds is made out, it can still allow enforcement to go ahead. So essentially, there's a residual discretion in the English court to allow enforcement even if the respondent party has shown that one of the grounds applies. And the best way of looking at this, perhaps, is in the context of public policy, and I think we'll be hearing a bit more about policy from other speakers later. But essentially, the English concept of public policy is something which is internationally heinous and totally outrageous. Essentially, things which would breach an English notion of public policy are things like terrorism, drug trafficking, people smuggling, that sort of thing. Any contract to one of those things would not be enforced in the English courts. That is a very narrow concept of public policy. And there's quite a good example of this, a case involving the enforcement of a Swiss arbitral award in the UK. Arbitral award made provision for payment of penalty. In Swiss law, it's okay. You can have a contract which provides for penalties, but of course in English law, you can't. And penalty clauses in English contracts are not enforceable. Nevertheless, the English court wasn't particularly impressed with the idea that this was a breach of public policy, and so it allowed enforcement of the award. And the basic reasoning was that the public policy of enforcing international arbitration awards outweighed the English public policy of refusing to enforce penalty clauses. So it's a sort of balancing of interests, and by and large, the public policy of pro-arbitration will always win. As a procedure, the English courts basically follow the principles very closely. An applicant for enforcement of an award make an application without notice, i.e. doesn't tell the other side what he's doing, applies in the English court, and then the English court will consider, the judge will consider whether or not to tell the respondent party about the fact that the application has been made. So most applications for enforcement in England involve the respondent not knowing that an application has been made until it's been served with the papers. And then the respondent has 14 days to file its objection to the enforcement. So you can get the sense from this that if you're resisting enforcement of an arbitration award in England, you're very much on the back foot, and the onus is very much, and the forward motion is with the claimant who's trying to get the award enforced. So that's a bit of general discussion of the New York Convention. Briefly, England is quite well known for its interim remedies, things like freezing injunctions and so forth. But those tend to be available as well for the purposes of securing enforcement of an award. It's possible to get a receiver appointed in relation to assets. It's possible to get freezing orders, possible to get worldwide freezing orders as well. So there's a whole array of English law mechanisms which are potentially available for a claimant who's in the process of enforcing their award to get security for the award. Turning quickly to ICSID arbitration. Now, ICSID arbitration comes from the Convention for the Settlement of Investment Disputes between States and Nationals of other states. And that was signed in, that was 1966. And that is a convention basically, as many of you will know, for the disputes between state parties and investors into their states. England, this is governed by different legislation, not the Arbitration Act, but by an act from 1966. And the approach in respect of investment treaty awards under ICSID is different to the general commercial arbitration award. There are no real grounds for objecting to enforcement at all, because under Article 54 of the ICSID Convention, all the state parties have undertaken to carry out an award, any pecuniary award, without delay and as if it was a judgment of their own court. So basically, the mechanism for enforcement of ICSID awards is totally separate from national legislation. So all that a claimant essentially has to do if he has an award, if he or she has an award against a state, is to bring this award to the English court, certify that it's an authentic award, and then serve it on the other side, on the state respondent. There are no grounds, public policy or anything else, to stop enforcement of that award. And then, I mean, recently there's been a few interesting cases on how ICSID awards are treated in England. And there was one recently, Borderlands Timber versus Zimbabwe last year, where essentially the court decided that the ICSID Convention itself contains the parties' consent to recognition and enforcement, that simply by being contracting parties to the ICSID Convention, all states had already decided that it was okay to recognize and enforce on their territory. Now, that is different, I'd like to add, to the notion of execution of an award. So on the one hand, you have recognition and enforcement, which is the way that you bring an award to a state and you get that award recognized within the legal framework of the enforcing state. That, of course, is different from execution, which is about the actual execution, if you like, the actual enforcing of the award against assets, the way of monetizing your award. That's ICSID in an outline. And finally, the issue of state immunity, which is very real, I think, to today's discussion, and obviously particularly the case of Ukraine and the actions of Russia, where at the present time there are many awards now being issued which potentially can be used and enforced against Russia. Now, state immunity traditionally was a complete bar to enforcement. However, most countries, and England is no, UK is no exception, have their what we see as a restrictive approach to state immunity. Now, the default position is that a state cannot be sued in the courts of another state. However, under the State Immunity Act of the UK, there's some exceptions to this. And one of these exceptions is the arbitration exception. So if a state agrees to arbitrate, then that is taken to be a waiver of what's called adjudication jurisdiction, i.e. court proceedings relating to the arbitration. However, that is different from execution jurisdiction. So unless a state expressly makes mention of waiver of execution, then it won't be possible to execute an award against state assets. And of course, traditionally, states are very, very limited in the way they treat state assets. Within the UK context, there is what's called the commercial exception. So if you can show that state assets are used for commercial rather than sovereign purposes, then they may be open to enforcement. However, there's also carve-outs to the carve-outs, if you like, and certain types of asset, notably assets of central banks, cannot be enforced against under any circumstances. That is an overview. There have been some recent interesting cases on state immunity in the UK. I think I should hand over very quickly, but one case of interest was in the UCOS saga, where Russia's obviously been resisting enforcement of UCOS-related awards for years now. However, they've reached the stage in the UK and I think in the States where these awards are basically going through now towards execution. And Russia's defences on the basis of state immunity have been rejected. And in the UK, the way this was dealt with by the Court of Appeal was Russia was saying to the English court, we haven't agreed to arbitrate. And the English court rejected that because actually in Netherlands, which is the seat of arbitration, Russia had challenged the arbitration agreement all the way up to the Dutch Supreme Court. The Dutch Supreme Court says, yes, there is an agreement to arbitrate. But the way the English court treats that is to say, sorry, Russia, there's an issue of estoppel. The question of arbitration agreement's already been decided in the Netherlands. Therefore, you have agreed to arbitrate. Therefore, there's no state immunity for enforcement proceedings. So that's the stage that's been reached there. Thank you
very much, Alex. Alex, a really important point about the assets as enforcement pool, and that organically connects to our second panel, where we're going to be talking about different types of assets to enforce against. But for now, I would like to introduce my New York colleague, Ridanya Perez. Ridanya works in arbitration for about 2 decades, and her practice is mainly connected to the insurance dispute resolution. So the floor is yours.
Good afternoon, everyone. A pleasure to be here. So my presentation is going to be a little bit about the current landscape in the United States regarding enforcement of awards. Very similar proceedings as the UK, and a very interesting distinction with respect to the UCOS case. But to start, the US continues to be a very pro-enforcement jurisdiction. Actually, a recent study from 2024 that looked at over 900 enforcement proceedings from 2011 to 2019 revealed that US courts give effect to over 90% of arbitral awards. That means that they're enforcing about 90% of those awards that get to court. The remaining 10%, it's where in most of the cases the parties reach a settlement, or the award debtor pays the award before conclusion of the court proceeding. So it's still a very pro-enforcement jurisdiction. Defenses to enforcement of arbitral awards under the New York Convention are narrowly construed. They're very limited and very rare. However, that's not to say that there are challenges that the investor has to be prepared for. The award debtor will always find some ways to delay proceedings and prolong proceedings in order to force the award creditor to pay or settle early on. But I think the main challenge that the investors have in the United States is really, again, it's having to defend the defenses, which end up prolonging the enforcement proceeding and then also adding costs. But the most commonly raised defenses in the U.S. are on due process, right? That the award debtor did not have an opportunity to present this case fully. However, violation of due process, again, is very rarely reviewed in the United States. There has to be a showing of a very serious and egregious procedural violation by the arbitration panel in order to be able to succeed in that defense. Obviously, the public policy defense, very common, I think, in every jurisdiction, but is also, again, very rarely reviewed. And it only succeeds in really extreme cases where there has to be a showing that the arbitration panel somehow was corrupted, or there has to be a very fundamental violation of due process. The most serious defense that is alleged against enforcement of arbitral awards is when the award has been annulled at the seat of the arbitration. And then there is a parallel proceeding pending the United States for enforcement. So you have the award debtor having an annulment decision from the seat, but you have the award creditor trying to enforce it in the US. What's interesting about the US is that US courts do not automatically defer to the annulment decision. US courts have stated very clearly that they have a discretion to consider whether to abide by that decision or whether they can enforce the annulled award. Now, in the instances where the United States have enforced annulled awards, it's when they consider that deferring to the annulment will violate public interest. And for example, just recently in 2023, there was a case that was settled in Bolivia, and the United States District Court of Colombia decided to enforce the annulled award, finding that if it did not enforce it, it will violate U.S. policy of reaching finality of a judgment. I also will violate United States policy of respecting the parties' expectations regarding their contractual obligations and U.S. policy of favoring arbitration awards. So even though it's very rare that the United States does enforce annulled awards, it does happen. But it's got to be some political motivation or corruption in order for the U.S. to not defer to the court. Now, in terms of investor-state arbitrations, the main challenge is sovereign immunity, which was explained by Alex. Now, the United States courts, they regularly defeat sovereign immunity when the state has agreed to arbitrate. So they enforce very rigorously the arbitration exception to sovereign immunity. Now, there has been a recent case which relates to the UCO's arbitration proceedings against Russia. Actually, the case was just issued in August of 2025, where the United States courts now have raised the bar to establish jurisdiction to enforce arbitral awards in state investor arbitrations. So contrary to the UK decision, the United States Court of Appeals for the District of Columbia said that even though the arbitration panel had determined that Russia had agreed to an arbitration agreement under the Energy Charter Treaty, and that the Dutch court had affirmed the award and found an arbitration agreement, that courts in the United States have to determine de novo, meaning they have to evaluate again whether a sovereign state has actually agreed to arbitration, that a U.S. court cannot defer to the tribunal's decision on whether there was an agreement to arbitrate. So in this case, the Court of Appeals sent the case back to the lower court, so the lower court could reevaluate if Russia had in fact consented to an arbitration agreement, and two, for the court to consider the binding effect of the Dutch court's decision. This has big implications for an investor, because this means that now a sovereign will get to relitigate consent. So an investor has to be prepared to build a robust record of consent by the sovereign. Now, this case in the United States is the Hewley it's called Hewley Enterprise versus Russian Federation, if anyone is interested in reading it. It's very recent. We don't know what the implications of that case will be with respect to exit awards. The Hewley case does not involve an exit award. In fact, United States courts that have entertained enforcement proceeding of exit awards have generally upheld those awards and rejected sovereign immunity in the exit context. So I think I'm just gonna probably reaching my 10 minutes. Some takeaway for investors is, United States is still a very pro-enforcement jurisdiction. One thing that I think the United States is known for is that it also provides broad discovery. Once you get to enforce an award, it becomes, a federal judgment. You could enforce it anywhere in the United States. But also, once you have the award confirmed and it becomes a judgment, the United States provides very broad discovery tools for an investor to seek discovery on assets in the United States and abroad. So under the US discovery rules, an investor that has obtained already a judgment can take the testimony of the award debtor and can seek discovery from third parties like banks. They could subpoena banks for records on assets. So I think that's kind of an advantage that the US has. Obviously, there are risks in enforcing in the United States. The risk is more practical, is that you have to be ready for prolonged fights, especially if you are enforcing an investor state arbitral award. You have to be ready for jurisdictional fights and to incur a lot of costs even before you get to the merits. So I think that's all my takeaways from the US.
Very much. So we just heard from two different jurisdictions which are widely considered as the most pro-arbitration jurisdictions to enforce arbitral awards. Ridania, of course, came from New York, which is the homeland of New York Convention. And it's quite refreshing to say that the dynamics there is also changing. But now we turn into the Ukrainian aspects, and we have Oksana Lehka from Asters, from Kiev. She leads the arbitration practice, and Oksana was part of the Asters team who recently got a few successes against Russian Federation. My congratulations again. So I would like Oksana to speak about the Ukrainian nuances, as how we see the arbitration enforcement from Ukraine, from the Ukrainian side. And that's mainly focused on the English audience as well, because that's something which is perhaps a bit different to what we get used to in a Commonwealth. Oksana.
Good afternoon, everyone. And first of all, many thanks to the
Yeah, that's good. Good.
But and many thanks to the organizers, to Kennedy's, and to Oleg for making this conference happen. And it's a great pleasure and honor to speak today here. It's okay. So when we speak about Ukraine's experience, of course, Ukraine is a country which is in the situation of war now, and public policy is the key aspect that is of interest. Is of interest. When there is an application to seek recognition and enforcement, that is before a Ukrainian judge, what is there's two situations when public policy argument can be invoked. First situation when the respondent or when the award debtor is a Ukrainian defense company, which is a state-owned company in the defense sector, I mean. So and the second situation when the applicant is the sanctioned company or a company, the UBOs of which are sanctioned. So speaking about those two situations one by one, when we have a Ukrainian defense company being an award debtor, and then there is again two scenarios. First, when the claimant that prevailed in the award is Russia or Russia-related company, or even a Russian state body. In this situation, there is a clear, explicit rule that the recognition and the enforcement of such an award must be refused, and the Ukrainian courts follow that rule unanimously. So, but when making that conclusion that the award should be, the recognition and enforcement should be refused, Ukrainian courts mention public policy, but without going into details. And Also, there are situations when the claimant and the award creditor is not related to Russia, but still Ukrainian defense company is a respondent. In such a situation, the Supreme Court explained them that the recognition cannot be refused. However, the execution of such type of awards should be postponed up until the legal regime of martial law is lifted. So we can see that Ukrainian courts tried to find the balance between the national interests and performance and obligatory nature of arbitral awards. This situation with the defense companies being respondents or award adapters is more or less straightforward because there are regulations in laws that help us. However, when the applicant is a sanctioned company or the UBOs of this company are sanctioned individuals, the situation is more complicated because there is no clear guidance in Ukrainian law what should be done in this regard. And therefore, Ukrainian courts had to build up their logic and their views how to deal with these types of situations. I think it was in 2020 or 2019 or 18 when we couldn't find a very controversial practice of Ukrainian courts. Even the Supreme Court sometimes saw that, being a sanctioned company and filling an application to seek enforcement would not pose a problem as such. And there is no argument of public policy that can apply into such situations. However, when the full-scale war started, the Supreme Court made a clear explanation, especially this concerned case when the applicant seeking enforcement of an award was Rosneft. And Ukrainian Supreme Court explicitly said, so sanctions is a new element of public policy. And when there is public policy, the fundamental principle of ensuring national security should be taken into consideration. And thus, when we have an applicant or a company that sanctioned that would prevail before because of the enforcement of an arbitral award, this means that the public policy exceptions should apply, and therefore the recognition and enforcement should be refused. However, the Supreme Court made a reservation that the refusal to enforce does not mean that civil law relations between the award debtor and award creditor terminate. So this means that the Supreme Court gave some perspective of enforcing the award in future when the sanctions are lifted. And if we look into those situations in Ukrainian courts, we see that the courts, they had quite an exercise of balancing. When on the one hand, they had their state, which is in the situation of war, and they had to preserve national interests. On the other hand, they had to consider that Ukraine is bound by international treaties, by New York Convention, and there is a limited number of instances when recognition and enforcement can be refused. So public policy appears to be the only way to deal with this situation, and the Ukrainian courts used this argument when considering whether to allow recognition and enforcement or not. As regards the immunity, the state immunity, while Ukrainian courts consider it certain instances when the applicant was a Ukrainian company that prevailed in international arbitration, in the investment treaty arbitration against Russian Federation. And I think that we all know the Everest case, where Everest company got a favorable award in investment treaty arbitration and filed a claim, an application, with the Ukrainian court seeking the enforcement against Russian Federation. To say briefly, because I think this case has already been discussed a lot, Ukrainian court found that Russia refused from sovereign immunity by signing the BIT agreement, where there was an agreement to arbitrate, and where there was a provision that the arbitral award would be final and binding upon the parties. I should say that finally the enforcement was successful, and shares of and the enforcement was done through sale of shares owned by VAB, a Russian alter ego company in Ukrainian bank. However, finally, the Russian company VAB filed the investment claim against Ukraine that is now pending. And actually, I have checked, and there are no pending applications on the enforcement of any investment cases against Russia that are pending in Ukrainian courts. So there are no such similar applications. And one of possible reasons for this might be the difficulty with finding Russian assets in Ukraine, because as you know, since the beginning of the full-scale invasion, lots of Russian assets were taken over by the Ukrainian state as a measure of forced takeover for military needs, and also a significant portion of Russian assets controlled by Russian companies were collected to the revenue of the state as an element of sanctions policy of Ukraine.
Thank you very much, Oksana. So of course, it's not a secret that we do have a significant interest from the Ukrainian companies and potential claimants in terms of enforcement of arbitral awards against Russian Federation. So quite a few companies sustained serious damages, and the whole process of arbitrating against Russian Federations is a less of a concern, where the enforcement part is pretty much the big challenge. And one of those companies is Naftogaz. And if you follow in the case of Naftogaz against Russian Federation over the Crimean assets, Naftogaz succeeded of enforcing and successfully freezing Russian assets in France. And on this note, I'm passing the floor to Thomas Kendra, who is based in Paris, to talk about how they succeeded.
Thank you, Oleg. And because I am talking about French law, I will be speaking with this accent from now on. No, not ready. No, there is one thing I have to announce. Very sadly, Oleg is no longer welcome in France, since he said a few minutes ago that the UK and the US are the most arbitration-friendly jurisdictions, because French people would be very aggrieved to hear that, having been the home of the ICC since 1921 and thinking they are the pioneers of arbitration. Fortunately, I don't have to make a choice or convince anyone. So I will speak briefly about French procedure regarding enforcement, and then a little bit about state immunity, because that's obviously one of the topics we're concentrating on today. So procedure regarding enforcement, it is very easy in France. That's kind of the message from most of us, but you have to go to the court with a very technical instrument called a pen. And I've done it myself many times, and you take the award down to the court and you have to write on the front of the award. I guess this procedure probably hasn't changed for 100 years, I don't know. And you write on the front that I am a lawyer, so you have to be a lawyer. I'm afraid it's not everybody who can do it. I'm a lawyer and I'm seeking enforcement of this award, basically in French, and you sign it. And that, for the purposes of getting an exequatur, is enough. It then goes before the judge. The judge gives a prima facie review that that basically there's an arbitration clause and there's nothing absolutely shocking, and then they will grant the exequatur decision. So it's ex parte. They don't tell the other side that that decision is being given. It doesn't take very long. My record is 3 hours. It was a $650 million award in the energy sector, and I understood later that the judge was going on holiday and he didn't want it on his desk any longer, and it came back to me after 3 hours. So you can get the execution decision very quickly. That doesn't mean you have the assets. There's another step after that, and there are possibilities to appeal the execution decision, which the other party can take. But for the original execution decision, which you can use to go out and get assets, that's all you need. In fact, 3 particular features of French law I wanted to concentrate on. That you can even apply provisional measures before you get that exequatur decision. You then have an obligation to apply for the exequatur, the execution decision, within a month, but the French law will even allow you to start provisional measures before you get that enforcement decision. Second aspect, the annulment application. So if the party applies to set aside the award, whether in the seat, if it's another country, or in France, that does not suspend enforcement. It does not prevent the enforcement going ahead. So it might mean that later, if there's been enforcement and they win on the annulment, the enforcement has to be wound back. But in order to prevent abusive applications for annulment, they say, no. Just because you say the award has to be annulled, that doesn't mean that it really has to be annulled. And so the courts will go ahead and enforce, even though there's an annulment application ongoing. And third aspect is the enforcing awards that have been set aside at their seat. So Eri talked about this a bit earlier. French law is very clear that you can enforce awards that have been set aside at the seat. The French courts will take their own decision as to whether there's an issue with the award. So the other party can apply to resist enforcement, but the French courts will not consider the annulment at the seat as preventing enforcement. I think there's a philosophical element of why that is. They think that arbitration awards exist in an international legal order. The French are very philosophical, so they have to come up with kind of philosophical ideas about what the award is, and that's the kind of justification for it. But also practically, it means that if there are abuses at the seat, and there are examples of awards being annulled for all kinds of ridiculous reasons because the state does not want that award being enforced. And there was one award in the Middle East, I recall, it was signed by a female arbitrator, and therefore it was annulled at the seat because that rendered it invalid. Those kind of ridiculous abuses can be resisted because the French courts will apply their own decision as to whether there is a reason to refuse enforcement. It can lead to some slightly strange situations where other countries, sadly, are less developed than France, like England. And the famous case in 2007, the Putrabali case, there was a first award which was annulled in England on a legal grounds because they hadn't excluded appeal on the grounds of law, and a second award was issued. The first award was enforced in France, despite its annulment in England, because they didn't care about the reasons for annulment. The second award was enforced in England. So you had 2 completely contradictory awards being enforced in 2 jurisdictions across the channel from each other. So the fact that we don't have an international set policy on this can lead to some strange results, but that's definitely the French attitude. And there is talk of reforming the French law at the moment, and they're talking about codifying that aspect. At the moment, it's just case law, but they're talking about putting that into law to make sure that it stays and it's entrenched in the law. So those are just some remarks on enforcement in France. And then to finish off with regard to state immunity. Now, state immunity it's kind of gone backwards and forwards in France. It's not quite as favorable as some of those other issues, other enforcement aspects I've mentioned. At one point, it looked like it was going that way. So there's a famous case of Crichton against Qatar, where just the fact of signing the arbitration agreement meant that you'd waived all immunity, including enforcement immunity. They said if you sign the arbitration agreement as a state, then you're basically accepting enforcement. So that was very favorable. That was in 2000. Then we've all talked about the UCOS cases. Of course, they had their own impact in France as well, because they were trying to enforce in all different jurisdictions. And in France, one of the problematic issues was that they were trying to enforce against lots of different assets, and they ended up with lots of contradictory court decisions, some of which found that the assets were commercial, some would receive diplomatic immunity, and there were contradictory decisions. And so the French government at that time decided to put in place a law that was sometimes called the UCOS law, more commonly the Sapin II, because the minister was called Sapin, and it was his second sort of major law, where you need to apply for prior judicial authorization before enforcing against the state. And that adds a hurdle, which makes things a bit more difficult, a bit slower, and you have to prove that the assets have a commercial purpose. Either there's been a waiver, they say, yes, you can enforce it against this asset specifically, or they have to be proved that they're commercial. So that was in 2017. That looked like we were going very sort of back towards anti-state enforcement. It's going to be more difficult. But recent cases suggest we might be going back the other way, and it's starting to get favorable again. Two recent cases. One I was going to mention to Dennis, I think he's had to leave, but he has to be careful with his embassy, because we've had two cases where awards have been enforced against what the states have claimed were embassies. And that's just this year in June and July, one against Iraq, where they said it was their embassy and so it should receive diplomatic immunity. Now, the court found that they only decided to call it an embassy once the enforcement action was started. So actually, it was just a house, and that they didn't. The court found that was completely made up, and so they didn't respect it. And another one against the Republic of Congo, case of Kimissimpex, where they enforced against what Congo said was a building used as an embassy for the UNESCO ambassador, and the state again considered that it wasn't actually an embassy; it was actually just used for personal and commercial purposes. There were two enforcement actions, one against another embassy. They said that's the embassy, that's okay, that receives diplomatic immunity, but this other one is not actually an embassy. So just it looks like the courts are getting a bit more open to considering methods of enforcement against states. Whether that has an impact on cases against Russia, we will see, but quite possibly, because it seems like the courts are open to listening to different applications.
Thank you very much, Thomas. Just for a record, of course, Paris is a pioneer of arbitration, and we're not even talking about football. Imagine our discussion about PSG and Arsenal. We have some time for a quick Q&A. So if we have questions from the audience, we would like to take maybe one or two maximum, because we are standing behind the drinks now. Okay, so that's it. So, oh, we have a question from the audience. Yes, can we pass the mic? Okay.
Thank you. Question for Thomas. You mentioned interim measures in France. Do you mean, can you enforce interim arbitration award in France if the arbitration was seated elsewhere, or you can apply to national courts for any conservatory or preservation measures? So how does it work? Thank you.
Yes, you can apply if the arbitration is seated elsewhere. There will be a very initial prima facie check, but yes, as long as you show that there's been an arbitration clause, and again, if you're doing it before you even have an exequatur decision, then you have an obligation to apply within 1 month for that exequatur decision. Otherwise, the measures will lapse. But yes, you can apply for provisional measures as soon as you have the award.
Just to build on that really quickly, tactically, Thomas, does it matter when you apply for interim measure before the exequatur? So can you get the freezer and then lose the exequatur procedure? Because that's the analog in the Dutch procedure.
You're unlikely, again, the exequatur is ex parte. So you're unlikely to lose on the exequatur unless there's really no award. I mean, it's completely fake and there's no clause or something. So yes, you can absolutely start the provision enforcement and ultimately lose. They may resist the exequatur. You can appeal the exequatur decision on the grounds, actually not the grounds of the New York Convention, but the slightly more limited grounds of the French law. The French law on arbitration is even more limited than the New York Convention, but basically the grounds of similar to the grounds of the New York Convention. So there is the possibility to resist enforcement. And yes, the court might decide in your favor, and then you lose your freezing order. But I guess the decision is made that they would rather prevent the abuses of dilatory appeals and dilatory suspension requests, rather than and make sure assets are frozen in the meantime. There is an exception if irremediable harm will be caused by the provisional measures. So you can apply. There was one case very recently, actually, where they said the company said, if you apply these measures, my company will go into insolvency, and that's completely unbalanced. And the court set down some rules saying, well, as long as you prove with your financial statements this and this and this and this, and they held in that case it was disproportionate, and so they wouldn't apply the measures despite the fact that the exequatur was ongoing.
Oh, thank you very much. I would like to thank our panel for today's discussion, and we have a break of 10 minutes, and then we're going to have a second panel where Olександра Черних will present the practical implications of the enforcement, so stay with us. Thank you very much.
Я в Швейцарії менеджмент, але я приїхав там розумники, коротше, це дуже просто. Ми тому що спілкувалися Ні, я розумію, але якщо ми говоримо, що це ми її туди привезли.
Тому що деякі країни співпрацюють президент UK через 3 місяці. Це ще не значить, що ти будеш президентом чи ні. Може бути 4 країн. Вони мені сказали, ніхто нічого не винен. Ракеті відповідали. Ну, ви ж добре сказати, що ще Київ в Україні 18 залишиться нас. Бо саме перший забувши за моє життя, який написав. Тобто не це ж плакав.
Реально, чесно кажучи, у нас не ситуація, тому що структурували теж Україні, а інвестор, що треба виїжджати, очень маса перевозить, бо як це не структурували. А потім вже таке, що там частина компанії в UK, десь ще, там продали, податки не слухали.
So enjoy the panel.
Yeah. Speeches, discussions, some practical insights,
Самі чистіші.
Вже всі частина вже від мене такі.
Yeah, sometimes if reminder about
And then it's like
Alex's presentation. It's really this
Очень хорошо.
So have a seat, please. Good evening, colleagues. Thank you for coming for our event. It's an honor to me start our second panel about enforcement arbitral awards. And thank you for our host, candidates, for organizers, and Spilka as well, and our guests from top legal companies from Ukraine and from United Kingdom. I'm Alexandra Черних. I'm head of enforcement committee of Ukrainian National Bar Association. I little bit know about enforcement process in different countries. Just today, my 21st year as I'm a Ukrainian advocate, but not so long like Norman invasion in UK after Thomas conversation and election about impact, French impact in UK, and we are all remember from first part French wonderful country for arbitration, but we are now start to talk about another jurisdiction, United Kingdom, Ukraine, United Arab Emirates, and Poland, of course. And our discussion will be little briefly because we mix question for different jurisdiction, and we will have just one presentation because we have a special guest star from crypto detectives teams, Alex, but all speakers will talk about our own experience after, and they will answer for our question. So my first question for this session about commencement of proceeding and recognition of arbitral awards. What's the first step for recognize and enforce a foreign arbitral award in your jurisdiction? We can start from Eva.
Thank you very much. My name is Eva Rutkowska, and I'm a partner at a Polish boutique law firm, KRK Legal, cooperating with Kennedy's. It's an honor to be here today and sit in this panel. I am a litigator, and I'm also involved in the arbitration scene in Poland. I am sitting in the nominating committee of the Leviathan Court of Arbitration, which is one of the major arbitration institutions in Poland that just celebrated its 20th anniversary. So I will be sharing my practical experience, and also I made an analysis of some recent jurisprudence of Polish courts for you from the practical point of view. So in Poland, it is very important to remember about formalities. And actually the motion to enforce a foreign arbitral award goes along the rules that are set by the New York Convention that was mentioned many times today, and the Polish Code of Civil Procedure actually mirrors what's written there. As I said, formalities and originals or duly certified copies, this is what is actually very important. And there have been a couple of cases where courts were refusing motions to grant the enforceability clause to a foreign arbitral award because certain documents were missing or the copies were not in order. And this is to be remembered practically. Poland is a very formalistic country, so remember the original of the arbitral award, the original of the arbitral clause, arbitration agreement, and a certified translation if these documents are in a foreign language. Remember to file it to a proper court. It's been at the appellate court for the 9 last years, which shortens the way for appeal. So it's an appellate court and a possible appeal on a very limited grounds to the Supreme Court. And remember to attach all documents, otherwise it's gonna cost and last very, very long.
Thank you very much. Dmitro, what do you think about your jurisdiction?
Yeah, hello, ladies and gentlemen. My pleasure meeting you in this room. So the interesting point is your jurisdiction here, because I'm a Ukrainian qualified lawyer, and I spent all my life supporting the Ukrainian project and so on. But historically speaking, so we were supporting many projects for our Ukrainian clients and some international companies in the Middle East, and particularly in United Arab Emirates. So we do have some experience in this project. So therefore, just your jurisdictions mean United Arab Emirates here, so that's like the first time I'm trying, but I'm like not qualified lawyer in that country, but do know something. And so the interesting point about this country is that it's a mixture of several jurisdictions, like common law, like continental law, and Sharia law. So everything is mixed, and the most important thing is successfully mixed. So if you look into their system, and this is crucial to understand how it's structured, so it has like 2 divisions. It's firstly, it's mainland, where the usual law applies, like Sharia law and civil law-based United Arab Emirates law. And they also have like more than 40 free zones, which are separate territories in the country and who have their specific regulations, mostly like procedural registration, etc. And it may apply. And some of these free zones, they apply common law, actually English law, and these are two free zones which are well known. One of them is Dubai International Financial Center, DIFC, which is located in the downtown in Dubai, very expensive and nice place. So, and where the candidate's office also present and successfully practiced, yes, one of the best law firms there. So, and the ADGM, Abu Dhabi Global Market Free Zone, which try to compete with DIFC, you know, but they're one step like behind them, but they're trying to do that. So these two free zones, they have common law, and that's definitely influenced the enforcement procedure, because when you come to the mainland, to the ordinary courts, so you must look at it pretty similar to what is in France, like Thomas explained in the previous session. But when you go to DIFC or ADGM, you may face certain nuances, especially in DFC. There they have their different court system. They have like an arbitration, Dubai International Arbitration Center, and they have the courts with appeals and high courts and so on. And these courts have the power to enforce inside this zone. And they have like a memorandum with the mainland courts where they can also apply for simplified procedures. So, and that makes this system very interesting for lawyer, from practical perspective. Like if we go, coming back to the question from which documents we should start, it's like everywhere in the world, nothing special. But all this, you know, territories, free zones, combination of law, and sometimes the implicability of Sharia law, which is also important, and you know, the cultural aspects, that's what make the country unique. Hopefully we'll discuss in more in detail during our further conversation.
Thank you very much. And Alexander Druk, maybe you have some advice about Ukraine jurisdiction. We all know this jurisdiction, and for your experience.
Of course, many thanks. It's also my pleasure to be here today to speak at this event. I'm Alexander Druk. I'm a partner at Ukrainian law firm Sayenko-Kharenko, doing arbitration, both commercial investment treaty, as well as cross-border litigation. In my practice, I do a lot of recognition and enforcement of arbitral awards. And from practical perspective, I would say that Ukraine is quite straightforward jurisdiction. There was a big procedural reform in 2017, 2018. And since then, the mechanism, how the awards are enforced, is very much like what Eva said in Poland. So there are only two levels of courts. So you file your application in the Kyiv Court of Appeal. That's the single court that deals with all recognition enforcement cases in Ukraine. And you also have the limited possibility to challenge the decision of this Kyiv Court of Appeal to the Supreme Court. So that's it. From practice, in terms of timing, let me tell you a story of the recent enforcement we had last year. So there was ICC award against a Cypriot company which had assets in Ukraine. So the client instructed us, as well as Cypriot law firm, to start parallel enforcement. So we filed in February last year, and they filed in Cyprus also at the same time. So in Ukraine, it's not 3 hours like in Paris, but we actually managed to get the decision of the Kyiv Court of Appeal recognizing this award within 3 months. So at the end of April last year, the court already recognized this award. Then the other side challenged it to the Supreme Court. And then it took some time for the Supreme Court to open the proceedings because there were some procedural deficiencies with this challenge. And the other side, the debtor, tried to cure them. At the end, the Supreme Court opened the proceedings in August last year. And then end of October, it already confirmed the decision of the Kyiv Court of Appeal and allowed the final enforcement. So after that, we were able to obtain the writ of execution to start the enforcement proceedings. Well, what happened in the same time frame in Cyprus? Pretty much nothing. So last year they did not even have a hearing in the court of first instance. The case was just pending there. And this year they had a hearing. in the court of first instance, and the case is still pending before the court of first instance. So that's the, well, comparison of the speed, what you can achieve in Ukrainian court, despite the current environment. But generally, even though Ukraine has some of these things similar to Poland, there are some formalities you need to observe. In reality, the percent success rate of enforcement applications is more than 90%. So there was a study by the Ukrainian Arbitration Association. They looked into more than 600 awards from 2006 to 2019, and the overall rate of success was around 93%. There were some grounds why the awards were not recognized, and probably we will look into them further. But overall, it's quite an efficient and streamlined system.
Next part of first question, we start also from your Alexander, about to what grounds do court most frequently refuse recognition, and how is old public principle applied in Ukraine?
Well, let's again, this comes back. I will be referring to the study that the Ukrainian Arbitration Association did. And in terms of the grounds, we already went through them in the first session. So there are a couple of grounds which the award debtor must present to the court, like the invalidity arbitration agreement or failure to serve the claim on the defendant, inability to present its case, maybe the setting aside of the award. And there are grounds like arbitrability of the dispute, public policy, which the court should itself examine even without the debtor raising objections. So looking into all these grounds, the most frequent ones, one is the due process. So this is the ability of the debtor to present its case. And mostly the cases where the respondent tries purposefully to avoid the proper service. So usually these are cases when the claimant submits the claim and the respondents try to avoid the service at any stage. The claimant then obtains an award, and then in Ukraine, the debtor tries to come up with different excuses why it did not receive this claim, why it wasn't able to present the defense. So there are a couple of these cases, and in terms of percentages, it's around like 3% out of 100%. So 3% cases, the debtors can be successful. So you need to pay attention when you have this kind of non-appearing debtor to properly notify it. The second most commonly used ground is public policy. So out of 100%, it's like 2% of cases. But that was in the period 2006-2019. Obviously, we also heard from in the first panel that now it could be probably more commonly used ground because there are much more situations with sanctioned entities, both on the claimant side and the respondent side. But overall, each other ground takes less than 1%. So in total, as I said, 93% of cases are successful. Only around 7% are not. And there could be like a combination of grounds. In some cases, the debtor raises wherever it could raise, everything. But in reality, it's not that the success is good for the debtors.
Thank you very much. Eva, do you have similar requirements and basis for courts in Poland?
Well, the situation looks quite similar, like in Ukraine, what we just heard. Namely, there is also a high percentage of foreign arbitral awards that get recognition and are enforced. The percentage of the rejections to recognize and grant enforceability clause varies from year to year, but it's above 90%. It's 92, 94, depending on the year, which shows that they are not really many, and that Polish courts are quite arbitration friendly and are respective for the foreign arbitral awards that have been issued abroad from for enforcement in Poland. The New York Convention is construed in quite arbitration-friendly way, as I said. So in the few cases that Polish courts refused the recognition and enforcement, the parties invoked the that there was no arbitration agreement, that the arbitration agreement was void. And although lower instance courts sometimes tend to be more formalistic than the Supreme Court, on the other hand, as far as this argument is concerned, overturned certain decisions of lower instance courts, saying that there is an estoppel to bring this defense that this argument that the arbitration agreement did not exist, because if the party did not raise this as an argument and as a defense from the outset in the arbitration proceedings, and actually defended its case in the arbitration proceedings, and only later, when the award was issued, is coming to a state court at the enforcement phase and saying, but I'm very sorry, but there was no arbitration agreement, so actually everything what we did before was in vain. The Polish Supreme Court follows the pro-arbitration interpretation, saying there good faith in conducting arbitration proceedings should be protected. So it would be unfair to accept such a defense at such a late level. To sum up, usually formal grounds regarding the lack of arbitration agreement, where successful defenses used by the defendant in the proceedings at the enforcement level. As far as the public policy clause is concerned, I haven't found any case law on this actually, so it's not really effectively used. And generally, as far as enforcement of foreign judgments is concerned, this clause is construed quite narrowly. So again, pro-arbitration in our case.
Thank you very much. So, start of enforcement procedure, of course, it's arbitral awards recognition. After, we should choose best way. So our second question for our next speaker, she has brilliant experience between two jurisdictions, Ukraine and UK, but any competition, I remember your advice. So, Seda, who is responsible for actual enforcement? State bailiff, private bailiffs, court officer in different jurisdictions, because you are Ukrainian enforcement officer, and you have experience working in the United Kingdom. So please.
Thank you very much. Good evening. I'm very happy to be here. I'm deputy head of a Committee of International Relationships of the Association of Private Enforcement Officers of Ukraine. I have experience as private enforcement officer in Ukraine and as a High Court enforcement agent in the UK. But today we're speaking about Ukraine. Yes. So since 2016, we have mixed system of enforcement in Ukraine. So we have state bailiffs and private enforcement officers. Basically, it's a similar, on one hand. So state enforcement officers, they're authorized by Ministry of Justice. They work under the rule of law. They allowed to enforce all types of judgments. On the other hand, we have private enforcement officers, and they're authorized and regulated by the Ministry of Justice and by law, but they're allowed to enforce not all type of judgments. We have a specific list of cases when it's not allowed to enforcement officers, private enforcement officers to enforce. It means when the state involved in the case as debtor or claimant, for example, in some family law matters or military authorities. For example, private enforcement officers, they work independently. They're financially motivated because all the costs of enforcement procedure is covered by only activity of private enforcement officer. And on the other hand, we have state bailiffs. They're regulated only by Ministry of Justice and only by state budget.
It's a good question for all speakers. Thank you. Thank you very much, Seda. For all speakers, about which enforcement tools are most commonly used in different jurisdiction. Eva, in Poland, maybe some interest in asset freeze and bank guarantees, checks, some different orders. I understand it's maybe very close to Ukrainian practice.
Well, you know, the easiest way is to seize the bank account because this is where the cash is, and this is the easiest and the quickest way. And this is the optimal way to go if there is something on the bank accounts and if this has not flown to foreign jurisdictions or virtual accounts like Revolut, but we'll be talking about this later. You know, if you are enforcing against an employee, but that's probably not very frequent, then of course the salary and real estate is of course also a nice asset to seize if it's there and if the ownership is with a company or with the individual we want to enforce against. But such assets as real estate, of course, take a lot of time with the sale and with the auctions that follow. So probably if you have cash on the bank account, this is the best way to go. The Polish specialty is that court bailiffs, because we don't have private enforcement officers, we only have court bailiffs. That bailiffs that are entitled to enforce under the law, they have a special online system to communicate with banks. It's called Ogniwo, and this is a very practical and efficient tool for bailiffs to ask banks whether a given company or a given person has a bank account at a certain bank, and then to follow with a freeze of this bank account if it turns out that the bank account is there. The problem is, of course, that if the money is abroad, this cannot be used. And another problem is, again, virtual financial services like Revolut. Revolut is not a bank under Polish law. It operates under the Lithuanian license, and well, it announced that it will be opening a Polish branch office, which will subject this branch office under the Polish regulations and banking regulations, but also under this virtual system Ogniwo, which will give bailies a very quick access to information about bank accounts.
We all know about a special English instrument. It's called a nuclear legal instrument, international freeze order. And I have next question to Dmytro about international freeze order in United Arab Emirates.
Yes, they do apply this concept and apart of that, also several interesting instruments which are quite specific for the country, which I'd like to share with you about how they call like worldwide freezing for orders, so international freezing orders. So they do it, but mostly through DFC free zone, which has a common law, and so they actively apply that, and they have a lot of like connections, memoranda across the globe who support DFC orders, and they're quite effective. So you do need to enforce it in the particular jurisdiction. It's not binding by default, so you need to apply to the local code. But nevertheless, it proves to be effective in many countries who are arbitration friendly. So yeah, they apply it, and at EGM as a second free zone applying common law, they are also trying to keep the pace with that. So it works. But what was very interesting for me as a lawyer from the Europe was a bit different instruments they are using. Mostly is the checks. So I honestly thought that checks is something which remain in the past. Yeah, you have to sign it with a pen. Yeah, right. So and everyone in the UAE, they use these checks. It's not like a surprise when you have a $100 million deal and someone will just write you a check in dirhams, right? So and it was very unusual for me. Why are they doing that? So but there is some pragmatic behind that. And what does it present? Firstly, so the check itself is as executory writ, so you don't have to go to the court and so like do all these procedures. So you just can go directly to the enforcement service and enforce it. So it's easier to do. Second, there are certain types of special checks called like manager checks, which are issued by the banks. And in this case, the bank acts as a guarantee, as a kind of guarantee. Yeah, so which also puts you in a very good position if you have to enforce. Second, until recently, I believe until 2022, if I'm not mistaken. So when the check was bounced back by the bank, it was a criminal offense by default. So simply, you could be put in jail or be subject to a huge penalty under criminal laws if your check was bounced back by the bank. And so nobody liked to play with that. Right now, it was decriminalized, but nevertheless, still, if there is a kind of fraud element in this, so you intentionally knew that you would not have enough money in your account, and you issued the check, so that again can constitute the ground for criminal arrests. So and also a couple more interesting instruments they're using. So the first one is ban to leave the country. So yeah, and you can get this as intermediate like about during the course of enforcement. So you can just like stuck in the country, not the worst country I believe in the world, but nevertheless, so you can be kept there. So until the matter is resolved. And in some cases, they do even issue criminal alerts, so the person can technically be put to prison. But again, there should be like a reason for that. Like the party who insists on this alert, they may prove that the defendant has money on the account, but trying to hide them. Like in this case, a person may be put in jail. So, and I had such cases in my practice. One of my client called and said that, look, my partner was traveling, and he entered Dubai just as transit area, and he was detained, and now they want to put him in jail. And it appears that like 5 years before that, they had a project in real estate, and they did not pay like $1,000 to some Indian guys, and so they applied to the court. And they never knew that there were court proceedings. So, but eventually he was detained, and luckily they found the claimant and paid him. So when he was released, so therefore these are quite interesting tools they use in these jurisdictions. Yeah.
Great. After your speech, I'm sure everyone in this room, when come to home, should find own checkbook from the British banks. I'm afraid I'll call to my wife immediately about where my checkbook, and don't want to go to jail if someone find my checkbook. In all jurisdictions, we have a special protected property from enforcement. Alexander, can you advise us about this practice in Ukraine, state companies?
Yes, in Ukraine, there is actually a long-standing problem starting from 2000s, where there was a law put in effect saying that property of state-owned companies, and state-owned companies is not only a company where the state has 100% equity, it's a company where state has 25% or more shares. So it actually captures a lot of companies. The real estate and production assets of this company cannot be enforced against. So only the bank accounts of these companies can be enforced against. And this issue, it was based on the law called the moratorium on enforcement of state-owned property. And it was because in the 2000s, there was a very widespread practice of creditors who were related to the management, who ran these companies inefficiently, and ran into a lot of debts. So these creditors who were related to management were just coming in and picking up the assets of these companies. So in a way, it was a bit like some kind of hidden privatization, where the companies were just taken out of assets, out of state-owned companies. It was temporary, supposed to be temporary. Until the improvement, actually, it also expanded. We already heard in the first panel about the new restrictions during the martial law. So the defense companies and some other strategic companies in energy sectors, they are protected during martial law from enforcement. In fact, all these restrictions, they are not viewed as inducing a good investment climate, and therefore a lot of institutions like the European Council, European Union, and European Court of Human Rights, they already commented on this practice. There is a task force within the Ukrainian government, and there are also international financial organizations who are looking at it to actually lift all this moratoria, because they actually hamper the development of these state-owned companies, because of this moratoria, some of the companies actually don't need them, but because they exist, the banks are not really, they do not like to lend to these companies at all, because they cannot take collateral, and they know that wherever they lend, they can no longer enforce. So this creates like a lot of burdens for the whole system. And for many Ukrainian state-owned companies, they cannot really borrow money on international markets without Ukraine as a state giving a state guarantee. So there is a lot of work in that area, and it's still pending. So we'll see what will happen in the next years, but probably most will happen after the lifting of the martial law.
Thank you very much. And also similar problem, as I remember, we have 15 different moratorium in Ukraine in enforcement procedure and also insolvency procedure. Now also one of our co-organizer, Ukrainian National Insolvency Trustee Association, and it's a very big challenge for all insolvency trustee to work with moratorium in Ukraine. And similar question to Eva about your experience about a special moratorium. Paula, do you have same?
Well, there are some provisions protecting certain kind of debtors that are probably not very specific for the arbitration world, namely farmers or healthcare centers, that there are certain assets to run the enterprise and to continue to enable the owner to continue the operation, or the healthcare center not to be deprived of the life-saving drugs and being able to continue the operations. But probably for the arbitration world, this will not be the full defendants.
Thank you very much. After recognition of awards, practical question, we'll start enforcement procedure, and next step will be asset tracing and serious challenges. And next speaker will be our unique, not lawyer in this panel discussion, Alex Fesun. He's CEO and co-founder of one of the biggest international company, Global Ledger, who have brilliant experience and working with law enforcement. Many governments, I don't know how many countries you support now.
I don't know, like
crypto expertise.
52 government organizations, international organizations are now clients.
And you have more than 100 detectives or...
Yeah, like 110 people in total.
Yeah. And they have brilliant, very modern computer, I don't know how it's called, but they can calculate crypto assets and trace and find it. And even they support Financial Conduct Authority, Home Office, Ukrainian government, and many international policy organizations.
Well, we call them 3-4-letter agencies.
Yeah.
Like
and then also from in his team have 2 guys with medal from Ukrainian service, security service as well. So Alex, my question about practice of crypto asset tracing and your experience in this field. And thank you for coming. It's really a challenge to invite you to legal events.
Always glad to. Like if we can launch, I prepared, like a SSS presentation. You know what is SSS presentation?
Yeah, we can
6 scary slides.
Can we open Alex's presentation, please?
Oh, okay. Yeah, I can do it like this.
Technology.
Yeah, technology. So, just I want to just because crypto may be very new for you in general. Everything we do is only related to the crypto. So asset tracing. We as a company, maybe you heard that Bitcoin is anonymous or something like that. We know maybe like 500 million plus wallets who owns them. For every transaction, like literally every transaction, we can say where money coming from, which legal entities or companies or individuals, and where they going to or went to. Examples I want to give you is just uncovering different aspects that you may not know about crypto and how to enforce and which problems you might run into. One of the first slides is actually about hacks. We analyzed almost 120 cybercrime events this year for the first part of the year. And the findings are staggering. I think that might be a good insight for you. So in like 68% of cases, you can see that money moved from the original wallets that, the hacker received these money. They moved somewhere faster than the company announced it to anyone, like law enforcement, or publicly announced it, or just made a PR announcement around that or something like that. In 22% cases, so 1 out of 5, the whole laundering process of these proceeds were finished before the public announcement. So 1 out of 5 cases already done. They are in unenforceable state already, like before the public disclosure. 31% cases laundered within 24 hours of the first move. 12 cases just moved funds immediately. And in 3 cases, hackers directly received money on a wallet. They, in some exchange, they've been cashing out later. Just the average numbers for you here, like we just, among these 120 cases, we did like average numbers. So the numbers between events are hours. So you see, like, in most cases, it takes about 200 hours to fully launder funds. And we're talking like big amounts. So if we go back here, I know you cannot see it because of the Zoom, but these 120 hacks, it was about 3 billion euro. So these are not like $100 things. So, and on average among these hacks, 200 hours, money is gone. Like they already cashed out in some shady exchanges, whatever, and you probably will not be able to trace them or have connection between them and that you can present to the court and things like that. So if you try to enforce something after about 8 days, your probability is very low. What I'm trying to say with these 2 slides is that if you want to get something in crypto back, then you have to be very fast, like with all these things. In our cases, we are fast, but then, in Switzerland, there was a case when the prosecutor for the case was assigned in 2 months. So we couldn't even send a proper email to the crypto exchange to block funds. In many cases, we sort of send email, people know us, or they are our clients, or they're in our network or something. So we can still block funds just by voluntarily collaboration of these exchanges, but it's not working everywhere. Another thing is very interesting. So you have to understand that bad actors, they learn, and they learn fast. And they have communities where they have conferences like ours. You see this picture over here? So they literally have a slide with a sanction evasion scheme, how to launder funds or move funds from Russia to United Arab Emirates. And the guy who's presenting it is this big guy, and this is the same guy in the orange shirt. He's the founder of Garantex, which is the biggest Russian sanctioned crypto exchange. Their volume for 2024 was 16 billion. Actually, I would later on say that about 1 billion of these funds are with UK licensed, clear, very nice entities, which is crazy. So these guys, they have a group like they meet. The group is called Sostav, which would more like Sostav преступления, which would translate to like elements of crime for my English-speaking audience. And it was funny, like they romanticize crime, and people there, you see, like these are 2 guys, these are related to crypto, but you have all sorts of guys in this group, like it's about 120 guys right now, and they are like porn sites, casinos, all sorts of dark and gray businesses, Russian, most of them. They have books, they share experience how one had the term in French prison, how his assets were seized, how he could have defended it, how he protected himself from Interpol and things like that. So they have lectures about that. Which is crazy. Like they learn and they have these schemes, and it actually has a very practical implication. So this is a scheme of Garantex, how they change their hot wallet every 4 hours. And this is what allowed them to have this huge exposure to the UK regulated entities as well. Changing a hot wallet for the non-crypto people, what means hot wallet is the safe of the bank. This is where your stash is. Like your client's assets, when they deposit it in the bank, they go to the hot wallet. And changing hot wallet is very unusual. That's like your bank would change your corresponding account in the national bank. It's like you don't change it every 4 hours. What these guys are doing, in crypto, you can do it. So they would mask it as a regular withdrawal. Every 4 hours, they would move the stash. And while moving the stash, they're basically making people believe that the money are coming not from Garantex, but from some new established exchange or something like that. So this gap in, let's say, some entities might just view it, okay, there's money coming from some big wallet or something, but it's not Garantex, it's not designated into sanctions or something like that. So seems like fine, I will accept it. And this is what happened with many European exchanges and many UK exchanges as well. And this model is actually being shared now on the market. Like this guy has lectures now, and they generally play with legal system that way. The Garantex got designated into sanctions. They renamed it into Greenex and moved funds there. And they, instead of making it a Russian entity, they made it a Kyrgyzstan entity or something like that. And then, well, next day you moved your stash to the new entity, and that's it. The legal system assumes that moving the whole stash of money to a new entity is not easy. I mean, especially if the entity is sanctioned. But funny enough, actually, in this group, the elements that I call them in English, FSB is present openly. It's another part that they collaborate with these organizations and helping with the models and bypassing them and things like that. And with that, you have to understand that Russia is still in the Interpol. They can read the whole database and the implications of that. This is actually another thing is that all these cases, when you want to trace assets, you have a tiny amount of time to really do something about it, but they are bloody complex. This is a case from 4 weeks ago. It's about sanction evasion. You see it's a person holding it. It's a person from law enforcement of one of the countries we work with. This is only a part of the investigation that they said they took it to the court, and this is only part of it. The whole investigation was 6x2 carpet. So they took it, they annotated it, and they've been presenting in the court like how money moved and why you should believe that movement and things like that. So in general, this is what you need to do in like 1 day. That's the reality of it. And what doesn't help as well a little bit is that the public policy doesn't help with these investigations. So sometimes, for example, one of the methods of people obfuscating the money flows is called mixing. What's mixing is literally like putting money together of many entities in one wallet, and then everyone takes the same amount every time. So it's like we're putting £100, and then every one of us on our new accounts, we take £10 each. You don't know which £10 are related to what person. So there's a company named Tornado Cash, which is the biggest mixer out of all of them. It was in the OFAC sanction list, and as you can see, they processed like 450,000 ETH, which would be about 1.6 billion at the current price. And most of them, they are like from hacks. And you can see these hacks, the names, they're directly traceable to them. So I think like PowerPoint's like messed up with percentages a little bit, but the ETH numbers are correct. And the funny part is that public policy in the US ended up lifting sanctions from Tornado Cash, saying it's just a privacy protocol, which is like not really cool, because before that, just the fact that money are from Tornado Cash made some exchanges already blocking them. So when you do what we call a demixing, so you try to understand the obfuscation path, it takes a little bit more time. Sometimes you need a custom write software for that and things like that. But it is possible. And before that, the entities would block money from Tornado Cash because they are sanctioned, and then you can come back later and say, oh, this is actually our money or our client's money. Now, that's a little bit more problematic. So just in general...
we are not ready. Not ready for this.
Yeah. I mean, I said 6 scary slides. This is not just to scare you. This is just to show you the scale of the problem, and maybe even like to say that, okay, you may not know all of this, and your clients may not know all of this, but there are Ukrainian Swiss specialists that know, and if we work together, that might be enough.
Thank you, Alex. And if Thomas told us about best result is 3 hours in court here, so I think 2.5 minutes for trace assets and stolen money from account. It's a good challenge for all of us, and I think for next few years, because for 2 or 3 years it's changed very, 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 very fast. So it will be normal practice for all of us, and we should be ready for working with documents like this. And I think it will be next stage of legal practice and competition in this market as well. And if Alex told us about sanction, my next question will be to Alexandra about sanction and enforcement and your experiences felt.
Yeah, thanks again. And we already heard on the first panel the issues with enforcement in Ukraine if there is a sanctioned creditor, a word creditor. I will briefly look into the issue where the debtor is sanctioned, whether there are issues with enforcement or not. From legal perspective, technically, there are no restrictions. So if you look at the law, there is nothing that prevents a creditor from enforcing against the assets of a sanctioned person in Ukraine. But in practice, the situation changes. So first of all, if somebody is under Ukrainian sanctions, the most frequently commonly used type of sanction is blocking of assets. So that means that this person cannot deal with assets, and to allow the enforcement of the sanctions, Ukrainian notaries, company registrars, depository institutions who deal with registration of assets are prohibited to actually take steps to enable these transactions. So even if the creditor recognizes the award in Ukraine and start the enforcement process, from practical perspective, even if you locate, identify the assets and start the enforcement, you can be blocked at this stage, that you cannot technically allow the sale to proceed, or even if you are successful with the sale, then state authorities could come back and start challenging these transactions. And that's the second important point, because once a person is sanctioned in Ukraine with a sanction of blocking of assets, starting from 2022, in response to Russian full-scale invasion, there was amendment to Ukrainian legislation introducing a new type of sanction, seizing of assets in favor of the state. So the state already used this a lot. This is a new type of sanction. It goes through the courts. The Ministry of Justice identifies these assets of person sanctions in Ukraine. They files a claim in Ukrainian court, and this person can defend itself, and the court decides on this seizure of assets. And what happens in practice is that whenever a private creditor tries to enforce, the state, including the state courts, can view the steps as trying to diminish the effectiveness of the sanctions that the state could take further, the seizing of assets. So there was at least one case where the creditor tried to enforce an arbitral award against Ukrainian debtor, which was under sanctions, and the Ministry of Justice interfered in this case, asked to be joined as a third party. They were joined, and then the Ministry of Justice explained its position that they believed that this creditor is actually a related party to a sanctioned entity, and this creditor tried to take over these assets to actually help the sanctioned entity to circumvent the sanctions. So the court in that case did not allow the recognition to proceed, and this was because in parallel there was already Ukrainian court proceeding on seizure of these assets in favor of the state. So whenever you have a debtor who is sanctioned in Ukraine, you are effectively competing already with the state for the same assets. There haven't been cases in practice where there was no seizure proceedings already in Ukraine and where the creditor comes, but we will see there could be some new cases coming up. We will see how did the courts react. But even if they allow recognition, there is still a practical issue with enforcement as such.
Thank you very much, Alexander. And also, I have one question to you as well about shares and enforcement against shares.
Yeah, if we look into generally different classes of assets that could be enforced in Ukraine, so I would just agree first with Eva. If your debtor has bank account in Ukraine, that's the fastest thing you can enforce, and usually the debtor doesn't even know. So usually the bank comes back to the debtor and says, oh, we received yesterday this enforcement order, the money already was withdrawn from your account, this is for your information. So the system works very fast. But if, for example, your debtor is a holding company and it only holds shares in Ukrainian companies, the enforcement would be much more difficult.
And it also depends on the type of the company. Either it's a privately held company or publicly traded company. In case of publicly traded, it's much easier because you have financial information on the value of their shares. If it's traded, you just look at the trading, what the price is, and it's quite clear cut that you can enforce. With privately held companies, there is a big issue with how do you value the shares. So under Ukrainian law, when the enforcement officer, either the state bailiff or private enforcement officer, they wants to enforce against the shares, usually it's through public auction. You sell the shares to bidders who bid for the shares, to buy the shares, but there needs to be a starting price. And for that, you need to value the shares. You need to understand what is the value. And to understand what is the value of a company, you need to have some financial data and information. And if the company is private, you don't really have any data in the public domain. The state enforcement officer, bailiff, or private enforcement officer can send some requests to this company to try to get this information, but due to different procedural technicalities, this company in itself is not the debtor, it's just the target for enforcement. So sometimes they just ignore these requests or provide inadequate data. And if the evaluation is not done properly, then the debtor, of course, comes back and try to challenge whatever the sale process you arranged. So we know the situation when some of the creditors are waiting for years to actually start enforcement against these shares in privately held companies because they don't have the information on the value of these companies.
Thank you very much. And now we are like between hammer and the anvil, between our expertise, experience, and very interesting topic about enforcement, arbitral awards, and network meeting after. So last question is for all our brilliant speaker about common advice about for your potential clients, about your about enforcement in your jurisdiction. Eva, you're first.
I would say make sure the arbitration agreement is okay, that you cover the scope that is capable of being resolved by arbitration. Make sure the language is broad enough to cover the disputes that can arise in connection with your agreement or with your legal relationship. Make sure the people who sign the agreement with an arbitration clause, which, as we all know, is a separate agreement from the main agreement and is subject to a different set of rules, that they are properly authorized to conclude the arbitration agreement. For example, in the light of the Polish jurisprudence, a general management power of attorney is not enough to conclude an arbitration agreement or to put to sign an arbitral clause in the agreement. So make sure if you sign by proxy that the proxy is properly authorized, because otherwise this may cause major problems later at the level of proceedings or enforcement. Well, make use of the standard arbitration clauses that are published at the web pages of arbitration institutions that you consider to use. I mean, this is always quite a safe option, I would say, and you know, don't muster too much so that you do not just spoil it to the extent that it becomes void. And when you have to enforce, apart from the formalities that I tackled upon before, when you already have the enforcement title, meaning the foreign arbitral award with the enforcement clause, then choose a right bailiff, because, as I said, bailiffs are state officials, but some are more effective and some are more lazy. So furnish them with information as much as you can help them. Use business intelligence, use tools to help them find assets. The asset tracing exercise is very difficult, as we all know in practice, can be very difficult. But again, help them, but also choose the right bailiff. That would be from me.
Thank you very much. Ukrainian creditors have a beautiful, brilliant chance to choose private enforcement agent. Seda.
From my experience and from my side personally, I truly believe that the enforcement system in Ukraine is very dynamic, proactive. It always moves very fast. Try to find the best solutions. Also, I agree with Eva that success of enforcement always depends on the right choice of enforcement officer. So fortunately in Ukraine we have some chance to find the best one. Yeah, it's like for business which has a lots of customers, it's like a dentist for the family, you know, to find your own enforcement officer. So and I truly believe that enforcement system in Ukraine can be a guarantee for international investors as well.
Right. So coming back to the Arabic world, again. So not mine, but I have to protect it here. So, but by the way, very nice countries, really, really very nice. So, and a nice environment, including the legal one. So, pretty dynamic and well developed. So, all the best to them. So, all this applies, of course, to which was said to the United Arab Emirates, but on top of that, just to several practical tips and hints. So, firstly, always write in the agreements that the client can reimburse legal fees, because like the practice in the UAE right now is very difficult to take it unless the parties explicitly agreed on that in the contracts. That's very important. Secondly, recently the UAE adopted certain procedural changes which makes certain notification procedures easier. Like it's sufficient sometimes just to send an SMS. This is a proper way to notify you about different procedures. So therefore, please pay special attention of what you are writing into the contract as a contact, especially telephone numbers and emails, and make sure they are working. You never forget about them, and so on. That's very efficient way, but from another angle, that's easy to forget sometimes for some of the clients. Yeah, so please pay special attention. The third practical hint is that when you start in any projects in the UAE, please pay special attention on the particular place. Like, for instance, if you would like to acquire a plant which is located on some free zone territory, some of the legal instruments may not apply there, or they can be applied subject to certain procedures, or sometimes you have to pay extra fees. Like, for instance, a Hamriya free zone in Sharjah, when you just change the assets, you have to pay 2% value to the free zone authority. Like, therefore, very important to understand where you have the project. And sometimes the clients, they register the company and then have to register another one because like it does not apply to the particular territory inside the country. And the last point practical I would like to underline is the license, because every niche activity in the UAE is licensed, and this is one of the ways how the country gets the money also, like, which is fair enough, I believe, for what they do for the business. And therefore, it's very important to pick up a proper license activity, because many things depend on this, including enforcement procedures, public orders compliance, and so on. Like maybe, and very, very last point is like also pay attention to the local culture, Shariat principles, some moral aspects, because we Europeans, we get used to some free ways, yeah, let me say so, like, and in that part of the world, some of the traditions are different, including in the law. Therefore, it's always like advisable to keep this in mind, and when you are drafting the contract, just to consult with local lawyers who can advise you not to be any surprises in the future. So that's like several advices on my side. Thank you.
Thank you very much, Alexander.
Well, from my side, I would say if you already know there will be a dispute, then you should think about injunctions, injunctions, and injunctions. So it could be even before you start your arbitration. We had one case where we got an injunction from Cypriot court in support of LCA arbitration against Ukrainian party, and the case settled before it even started. So now it's also possible in Ukraine to get injunction in Ukraine in support of pending arbitration, irrespective of whether this arbitration is held in Ukraine or outside. And it's possible also to get injunction when you start recognition enforcement. So once you file an application, you can also get provisional measures. So it's not like in France, you cannot get them before you file, but you can get them right when you file. You ask for this. But even if your debtor is really shady and tries to actually siphon the assets out or transfer them somewhere, recently there was a very good practice of the Supreme Court on unwinding this transaction. In the past, you can only do this in bankruptcy. If you put your debtor in bankruptcy, there is like a 3-year period when you can try to challenge this transaction on certain grounds. Now it's also possible without opening bankruptcy proceedings. So if a debtor, knowing that there is a claim, tries to sell the assets at undervalue, transfer it to some related companies, do something else, for example, enter in some arrangements to put them into long-term lease under very low lease rate or something like that. All of these things could be challenged by the judgment creditor once it obtains the recognition of the award in Ukraine. It can immediately start this in parallel with enforcement.
Thank you very much. Give advice for clients about crypto assets.
A story.
and speed.
Yeah, it's a very short story. Back in the day, one of my first encounters with law enforcement was with one of the 3-letter agencies. They came to me. I haven't even started GL yet, and they busted a Carders site where people were selling credit card details for Bitcoin. And they busted, and a part of the things they seized was Bitcoin mining equipment. They came to me and they said, "We don't know what that is, but people say it's downloading money from the internet." Which is, frankly, is the best explanation of Bitcoin mining I've ever heard. So the moral of the story is pretty simple. You have to have, if you have cases with crypto, you have to have a specialist to answer these questions. That's it.
Thank you. Thank you very much. Thank you for our hosts and organizers, Kennedy's, Sayenko Kharenko, Asters, Spilka, Ukrainian National Bar Association, Association of Private Enforcement Officers of Ukraine, and Ukrainian National Insolvency Trustee Association. Alexander Bondarchuk still together with us, I hope. And for final speech, I want to ask Oleg Shulka from Kennedy's.
Thank you very much. I will be brief. I know we're all waiting for the drinks. 3 takeaways from me from today. Number 1, France is very good jurisdiction, as my boss kindly reminded me. So, yeah, I got my visa back. So effectively, it's really, really good pleasure to see you all here from all sorts of the parts of the world, from Arab Emirates, from Poland, from Switzerland, Ukraine, of course. We have distinguished law firms and organizations back in this panel. So thank you for all of you for coming, because that's the testament that we're actually doing something meaningful here. So you came here to hear what we think about the development of a practice, about the trajectory of the practice in general. and it seems like it's quite relevant. Real takeaway is that the enforcement is not that difficult, unless you deal with crypto, obviously. Reasonable jurisdictions where your businesses came from or might come from, or your clients, usually support enforcement. And that's the takeaway you should take with you out of today. Obviously, you do have complications, you do have underlays, you do have nuances, and that's why we are here to explain you all that. But in general, you should not be afraid of arbitrate as opposite to litigate, and because at the end of the day, the process of enforcement, that's where it counts. And I would just extend our thanks to Ukraine National Bar Association as well, and to the Ukrainian practitioners who are battling through much more serious problems that we are here about the legal nuances. And hopefully Ukraine will rejoin the active legal scene when the war is over. And hopefully, the climate will allow us to work with Ukraine as before. And as we hear from our distinguished speakers from Ukraine, these things are moving in the right direction. So Ukrainian aspect is a good aspect, not the problematic one. Thank you very much.